March Visa Bulletin is out. Updates on interfiling, a little bit more discussions we are going to bring to you on that, and some current events. So stay with us and we will break it down for you. Thank you. Okay, so the March Visa Bulletin is out, and if you are in the EB2 category or close with a close date, it's good news for you. There's a 6 months forward movement there, but nothing else. No movement.
5 months, I think. Wait, 4 months. 4 months.
4 months.
4 months EB2 final action date.
Yes, 4 months EB2 final action date movement for India EB2. No movement for China whatsoever, and no movement in EB3. Along with it, there is a renewed push.
Interfiling, yeah.
By USCIS to interfile. As a matter of fact, they've released
well, they sent out this cute email to anybody who subscribes to USCIS emails. There's a nice printed copy of it. And they've updated their policy, so about like, what is it, 3 weeks or 4 weeks ago now, they put this big interfiling thing on their website encouraging people to interfile, and they've sort of updated it and expanded it.
They were not encouraging people to interfile. They were strongly encouraging people to interfile.
Yes.
They used the term strongly encourage people, and then they've explained why. There's no significant substantive. There's one substantive clarification they've made in there that we're going to bring to you, and more of a push, and basically saying that also they're going to give us a hint on the future of the EB3.
Yeah, I take that with a grain of salt, though, because this comes from USCIS, and the Department of State controls the Visa Bulletin. However, they do know, they have some experts there who know.
Are you telling me that the left hand doesn't know what the right hand is doing?
I mean, Sam, I imagine the left hand, in one room, the right hand, in another country. That's how far apart they are sometimes.
Yes, no, that's a good point. But also there could be coordination.
Well,
as well.
I cross my fingers. I hope they better organize themselves. It's only good.
Yes. So let's talk about the Visa Bulletin. Let's talk about the dates, Brian.
Yeah.
And,
do we want to just put them up there and talk about them?
Sounds like an excellent idea.
So we're going to start with the dates for filing, and there they are for March 2022, and not really much has changed. Nothing has changed here. So what does that mean, Sam? It means, for me, we're not trying to get more cases in our offices right now. We're not trying to bring in new adjustment of status cases, mostly. I mean, you're gonna make a counterpoint, I imagine this is, but Brian, the final action dates are moving. That's encouraging cases to come in, right?
Well, no, I think you're mostly correct. I mean, yes. I mean, there's no movement with the filing date because the filing date is the earlier date, and that's the one that really makes people. But when they move the final action date, they're probably trying to. I'm assuming that is working in conjunction with this interfiling push.
Yeah. So that's an interesting thing to talk about. So we'll put up the final action dates here as well, and that's where the movement is. You see that EB2 India has made it all the way to the 1st of May of 2013, and that's again a 4-month movement, as we discussed.
And that's a
earlier.
good chunk of territory. I mean,
that's huge. I mean, historically, we're used to seeing it. As attorneys, we check the Visa Bulletin every month, and I just remember, it moved a week. Nothing.
So they moved the final action date, and you would assume that when you move the final action date, and the filing date does not change, you would assume that this is really aimed at wanting people to interfile.
Yeah.
It is really designed to move things from the EB3 to the EB2, and they're saying that we are not going to trickle down. And we're not going to move the EB3. It doesn't look like there is an intent to move EB3 forward in the foreseeable future.
Or, the EB2 dates for filing. I mean, this is something we were talking about for this right before this presentation. And instead of moving the EB2 dates forward, just keeping on moving the dates for filing and the final action dates forward, they're basically effectively pausing it by not moving the dates for filing, right? And they're inviting those EB3s to come over. in theory, Sam, they could just basically say, they could not promote interfiling, and they can just keep on moving the EB2 dates forward, assuming everybody's in EB3.
They can move the filing date because, see, the filing date is easy to move. There's no regulatory guideline. There's no guidelines. It's basically, it's a policy. But here they're saying that these visas cannot be made available, and I'm quoting from this public engagement release that they've sent out on Friday. These visas cannot be made available to applicants in the third preference category because given the significant number of non-citizens awaiting visas in the second employment-based category, these visas are required by statute to be used for the second preference category.
Well, short answer.
A little bit of a double talk here, but
I'm going to be the unusual for me, try to make it simpler. There's tons of visas available. There's no chance of them rolling down to the EB3 category. If you want to get yours, get in the EB2 category.
And we just moved the final action date forward. And also they're asking people to interfile, obviously, for those who are third preference category is not available. Again, this is all policy. This is all encouraging, wanting you to do, encouraging you to do. Nothing, there's no, this is not, you must do it. But it says here, if you have a pending adjustment status in the third preference category and the visa is not available to you in that category. Yeah. So they don't want you to move interfile to the second preference if you are current in the third preference.
Yeah, which is kind of the prevailing logic. If your priority date, your final action date is current in the EB3 category, that means they have a visa available for you in theory as of today, meaning why would you jump to the EB2 category? For the record, this fun little email that USCIS sent to us, it is available in content on the USCIS website as well. I'll show that to you guys real quick here. If you do a Google search for USCIS green card, at the top of the page, I'll show you that page. There it is. It'll have this little alert up here. You can go to the green card for employment-based immigrants. And at the bottom, you will find transfer underlying basis. And this is the thing. This is the page that caused a stir a couple weeks ago, and they've updated it and expanded it with a little bit more information. And that's really what we're talking about. It's the same basic content.
But it's not word for word.
Not word for word. There's a little bit more content in the
There's
email.
more here.
But there's a lot of the update is available on this website if you want to read about some.
Do
of the
they use the
stuff.
word strongly encourage here?
No, I don't think they have the strongly encourage. Actually, is this the page? No, they don't have the strongly encouraged.
So
language
here,
there.
so here they have a language called "We strongly encourage you." We strongly encourage you to consider requesting that USCIS transfer the underlying basis of your pending I-45 application to the preference category where you have available visas. Making such a request, and that's where they back off a little bit because they're pushing it hard, and then they say, okay, making such a request is a decision of each applicant and should be made based on your particular circumstances. So that, for me, is telling you that just don't jump in there, and if things don't work out for you,
we're not telling you to file. We're not telling you to interfile. We're just strongly encouraging you to interfile. Kind of doublespeak, Sam. It's kind of a check your rear language plus strongly encouraging.
Strongly encouraging, but depend on your circumstances.
Yeah.
Strongly encouraging, but we're not taking responsibility for it.
Yeah.
So what are those circumstances, Brian, that would render someone whose EB2 becomes available but cannot or should not interfile?
Should not interfile? Well, if you're current in EB2 and you're already current in EB3, no sense of moving to the EB2 category. They're telling you that specifically. They're telling you that specifically here. And again, like I said, if your priority date's final action current in EB3, there's no sense of doing it. You're just adding another layer of complexity to your case. If you want to see your green card approved, stick it out in EB3. Seems to be the wise move.
What is not clarified in their policy is how they handle the Child Status Protection Act.
Yeah.
And if you're locked in under the Child Status Protection Act in EB3 and your child is now over 21,
could be,
and you interfile to EB2, and the numbers don't add up because you have to calculate the credit for the I-140 on the EB2 as opposed to the EB3, it could spell
devastating and mean your
devastating.
older child doesn't get a green card.
Yeah.
But that's okay. USCIS told you should make a decision based upon your particular circumstances.
Yeah, exactly. Exactly. You're on your own. We strongly encourage you, but you're on your own.
Yeah.
Okay, so that's interesting stuff. And then they also advise you on the medicals.
Yeah, so they have a couple interesting things in this policy. So one, they say, and this is something we already strongly suspected, and we advise people of sending medicals to this address. They say, don't send your medical exams to that new interfiling address in California. Don't do that. I think that was obvious to me as an attorney. However, it's something they really explicitly saying out there. Something else I got to point out what it says there, Sam. They kind of say don't submit a second. It can be interpreted to say don't submit a second adjustment of status. And I'm going to read what it says verbatim here.
Yes, thank you.
Submitting a new adjustment of status application is not required to transfer the underlying basis of a pending Form I-45 and will not result in adjudication of the benefit request, in faster adjudication of the benefit request. So submitting a second 45 will not result in faster adjudication of the benefit request.
So okay, all right, okay.
So
yeah,
they're saying to transfer underlying basis, you don't have to submit a second I-45. And it says that won't make it go faster, but do they mean that your second I-45 won't make your case go? Are they telling you that the interfiling is going to be faster, Sam?
They're not telling us faster. They're not saying that interfiling is faster, but they're saying that filing a second adjustment will not be faster.
It sounds like
one is telling you one is it's presented in the negative. They're saying filing a second adjustment is not faster.
Yeah. So if this filing a second adjustment is not faster, ergo the alternative option of interfiling.
Not necessarily. Not necessarily.
Okay.
Because if that's the case, they would have said, we believe doing an interfiling is faster than filing an adjustment of status, second adjustment of status.
I don't believe they would ever be so clear, Sam.
Exactly.
When I first read this, I said to myself, I really hope they tell us which one's going to be faster. So what else is it saying here? There's a couple other interesting things.
It reminds you about the discretion. I mean, obviously, that they may not accept it, right? Don't do another adjustment of status. You're on your own. Every circumstance is on their own. We strongly encourage you, but you're on your own, and we may not accept your interfiling.
Yeah. And
you're not going to get you lose your 180 days portability, right?
Yeah.
You start all over again.
They explicitly confirm there. It says if USCIS grants your request to transfer the underlying basis of your Form I-45 to a different employment-based category, the transfer request resets the 180-day clock for eligibility for the portability provisions. Sam, I have a lot of issues with this language right here. It says, if USCIS grants your request to transfer the underlying basis of your I-45 to a different employment-based category, you never know when they grant their request because it's an interfiling. They never tell you. The transfer request resets the 180-day clock for eligibility.
Right. Well, that should be as of the date of the filing.
You would think, I would hope, but I guess they've maybe drafted this imprecisely.
Yeah. So now listen, everybody. We're lawyers. We tear things up because that's what we do. Interfiling can be good for a large number of people, but interfiling is not good for everybody.
Yeah.
And they haven't clarified. It's something that I would have loved for them to clarify was something that we've said time and time again, that interfiling is only based on final action date, not filing date. And if you interfile before the final action date is current, meaning that if you interfile too early, it can throw your case in a dilemma because you would think that you've interfiled, but in fact you have not, and you do not know when to calculate the 180 days. And also, they may reject it altogether as untimely or too early filed, or so it creates all kind of complications. So you got to get that final action date before you interfile. And we had this old chart.
Yes, our old friend, the which one wins adjustment of status versus interfiling.
Let's go over it one more time.
Let's
what the heck?
put it up here. Yeah, there it is. Our old friend.
Okay, so let's start backward because the speed is what USCIS addressed.
Did they?
Well, they did talk about it.
Well, so here's something I wanted to I mean, perhaps, I mean, we've heard anecdotally, and I've seen it, I guess, too, that, you know, if you have a already approved EB2 I-140 and you file a second adjustment of status, they can approve those cases faster when there's not a pending I-140 with it. Interfiling, though, I mean, well, so speed. You really want to talk about speed first, Sam? This is the hard one. So if you transfer under, if you know, in order to take advantage of this massive amount of visas, there's 140,000 visas available in the EB2 category this year. You have to get yeah, you have to get that before the end of the fiscal year, right?
Yeah.
And the question is, can you get it, if you file a new adjustment of status right now, is that going to get approved? Are they capable of approving that before the end of the fiscal year?
I doubt it.
See, that's where I'm at. And then that leaves you with interfiling. And interfiling, you know, you have a chance. You know, you are more or less officially in the category once you interfile, you know?
So if you're not changing employer, you don't have Child Status Protection Act, you don't have children aging out issue, and you're stable and your EB3 is not current, but under EB2 is, then I think interfiling is a serious considerate, but discuss it with your attorney first.
Yeah.
If you're contemplating moving around soon to a different employer, or if you have children who are older, and I'm sure there's other circumstances that we've overlooked.
So the second adjustment of status? Sure, yeah. I can think of a great one. I mean, if you don't think your final action date's going to...
If your EB3 is current,
yeah,
and you want to take advantage of EB2, they're telling you not to interfile.
Yeah.
Well, they're not encouraging you to interfile. Yeah, I would say another.
I got a scenario where you want to do a second adjustment of status. Your dates for filing for EB2 are current, but your EB2 final action date's not current. If you want to try to get in the, you know, that might be a scenario in which you want to try to get in the. If you think
so, this is a great one. Sorry to interrupt.
I'll keep on going forever, Sam.
Yeah, no, that's a great one. I think you need to take it slow and explain it to everybody because this is very important.
So, if your EB2 dates for filing, which they're accepting right now, is current, but you're not final action date current, you might want to consider filing a second adjustment of status because
into
the EB2 category.
Because you really cannot
interfile
until the final action date. So yeah, so absolutely.
I mean, for right now, that's your only chance of getting into the EB2 category at the moment. And if your position is my EB2 final action date is probably not going to become current in this fiscal year, you may as well file that second adjustment because at that point, if you have again, the big benefit of having that second adjustment, Sam, is once you have two adjustments out there, you don't have any worries.
Yep.
You know, you can just find USCIS, wait until pick whatever case of mine is approvable first, and approve it for me. You're done.
So if your priority date is after September 1st, 2013, but before, right?
Yeah, before May
1st, 2013. July, August, June 2013, these dates, you're not in the final action date yet in EB2 and cannot interfile, but you have surpassed the filing date. That's an opportunity to do a second adjustment to get into the EB2 and have a dual track.
Yeah.
Now, they may move those dates later.
Yeah, that's the
and
other
you
thing.
can do an interfile then.
Yeah.
Which is perfectly okay. We've discussed having a case in the EB2 and interfiling into the EB2 as well.
Yeah.
And that's a possibility that you can do.
Yeah. It's not really a
yes.
challenge, yeah.
Okay, wonderful. So those are great stuff, Brian. Anything we need to eat on maybe predictions?
Yeah.
What do you think about EB3?
So EB3 hasn't moved in the last 5 months. EB3, anything. This lovely letter from USCIS, this email from USCIS says these visas, these massive amount of visas that we have aren't going anywhere. They're not going into the EB3 category, not a chance. It seems to point to me, at least, that this EB3 dates aren't going to be moving until October of this year, when the new fiscal year begins, would be my guess.
So do you think if you don't have those concerns that we've raised, would you recommend interfiling? I think we haven't gone through our chart yet. Would you recommend interfiling if we don't have somebody moving out to a different employer, no child status issue, and EB2, EB3 is not current?
EB3 is not current, but EB2 is.
EB2 is.
Yeah.
Then interfiling is a good option.
Yeah.
But if EB3 is current, I will be reluctant to interfile.
Yeah.
You can do it.
Yeah, it's just it's again the Visa Bulletin. If your final action date is current, that says we have a visa available for you, and the only reason we haven't gotten to it is because we just don't have the capacity to pick up your case yet.
Is EB3 moving this year?
I just don't see how it's possible. All signs point to no. Everything points to EB2 moving.
Yes. Current events or there's more things we talk about?
Well,
have we put that chart?
We've only put it up for a second, but we didn't really go for it because we got stuck on the interesting issue of speed.
Yes.
And let's talk about the other things.
All right, so let's take it from the top down.
Yes. So costs.
Interfiling wins.
Yeah, you don't have to spend $1,200 a person for an interfiling. It's
yeah.
One letter can cover the entire family.
Yes.
Notice.
Notice, obviously, there's no questions. Adjustment status wins.
Yeah, you get receipt notices for that. And I got to point out, we've sent out a fair amount of interfiling requests to this California address where they say, send us your interfiling request and send us a supplement J. Crickets in terms of seeing receipt notices on those supplement Js. And supplement Js can generate a receipt notice.
Right.
And they haven't generated any for us from that area.
Right. Discretion, which one wins?
Adjustment of status. There's always discretion in adjustment of status, but interfiling adds another layer of discretion.
It's way wide open.
Yeah.
Interfiling is wide open.
Yeah.
In terms of discussion. Peace of mind. Clearly, for me, adjustment is a piece. Yeah.
You get receipts. You get a case number you can track, and you can. Yeah, exactly. Yeah. Protection.
Yeah, adjustment is a lot more protected. Interfiling, you're basically, it works, but it just works because they make it work, but it can break down. We've seen things break down.
Well, I just think of I want to build a problem-proof immigration shell, and I love having a non-immigrant status to keep me in status, and a pending adjustment of status in case that falls apart. And I sure as heck would like to have another pending adjustment of status just in case there's some sort of problem with
not
the first
an interfiling on the adjustment, not knowing what the heck is going on.
Yeah.
All right, so
and
filing requirement flexibility.
Yes. So basically, to file that second adjustment of status, you have to be in status, H1, L1, H4, etc. Whereas you don't have that requirement for interfiling, which that's...
And that's another reason sometimes you do an interfiling over, that's a good one. I'm glad you brought that chart because if you're not in status, you cannot file a second adjustment.
Yeah.
You have to be in status, but they seem to accept interfiling because it's really what it is just moving the adjustment from one category to the other. You don't have to be in status.
It's not a new case per se.
As long as at the time of filing that adjustment that you are moving, you were in status, then you can interfile it, which is, I think, definitely a big plus for interfiling.
Yeah.
Absolutely. That's a good chart. Always love having that chart.
Love that chart. We're getting mileage out of that chart, Sam.
That's a great.
We've already brought it up in 3 or 4 presentations.
And
so far.
we've overlooked a couple of things when we look at that chart. Boom.
Yeah.
Yep.
So one,
moving to trends.
Trends, yeah. So
Screw ups by USCIS?
Question mark. I'm not sure what this means. So in the last couple of days, I've gotten a lot of emails from people. I know you've gotten emails as well, and I've talked to other attorneys in the office and attorneys not in this office, and hearing from clients saying, hey, my EAD got approved, but my AP didn't get approved, so I got one of those, my EAD card, but it's not a combo EAD AP. It's just an EAD, and my AP is still out there pending. And it seems to be a trend right now.
Yes. I think it's more on the good news column, not on the bad news column, but I think what's happening is USCIS is pushing those EADs out so aggressively that they're not going to wait for the advanced parole to be approved if it's held up for whatever reason. It doesn't mean there's anything wrong with your advanced parole. All what it means is that USCIS is so committed to pushing out these EADs to get them out to you in your hand, such that they have made the decision that they're not going to wait to issue a combo card.
So, yeah, that's one way to look at it. Perhaps, I mean...
That's the only way to look at it.
The people who I was talking to, I looked at their EAD case and said, well, okay, that EAD is approved pretty fast, but it cheeses me off, Sam, because that AP is a simple form. It's even compared to the I-765, the EAD form, it's dead simple. And, I guess...
Okay, they're going to hold it for you.
Well, congratulations,
another
Sam.
week.
You've satisfied with your fast EADs all the people who want an EAD. What about the people who want to travel?
Yeah. Well, but that means, okay, so you wait for the EAD together.
Where's my advanced parole? I want to
advanced
travel.
parole is not moving faster, it's moving on the normal pace. So they would not have traveled because the EAD would have been delayed for the advanced parole, so it would not have affected their travel.
That's a very much a glass is half full kind of argument.
No, it is not a glass half full or half empty argument. It's a factual argument. The advanced parole is moving on a track that is not impressive but normal. They're putting all their energy on the EADs.
I'd rather have them impress me on both of them.
Right, but I'd like the sun to shine from the east and the west at the same time too.
Well, okay, all right, fair enough.
I got to defend USCIS on something, beating on them. I mean, this policy for me, this cute. I like the keyboard. How do you like this keyboard?
They went to the stock image website and websites like we sometimes do and got picture of somebody working. Yeah.
And it's a PDF, attached PDF, and it has different. And there's some bolding.
Yeah. Yeah, no, it's a lovely document, and again, Sam, big picture. We decided we want to grouse over this thing all night. However, what the big headline is USCIS. They realize they have a ton of green cards to get through, and they're trying to get through them.
Yes, absolutely.
And I like that. We're trying to avoid last year's disaster of wastage.
Yes, are they going to?
So
I can't wait for the numbers.
I know.
The numbers are not out yet. For those who
unless
are
they've
going
updated them in the last 12 hours. Yeah, they're not out there yet. But I'm looking to see what USCIS says about their numbers. And again, when we looked at the last fiscal year, it was slow in the beginning, got a little bit better, and they really crushed them out at the end.
I think there's a push here.
I think there is a push.
Yeah.
And I'm.
I tell you, it's definitely. A better, more improved situation than we had last year.
Agreed.
I'm curious to see what happened to the consulate approvals because of the overflow that's coming at the end of the year for the poor folks from China and India for next year. See whether they will get more green cards.
I mean, when we looked at those numbers, we thought it was about the consulate seemed to be up to about 90% of capacity. Uh-huh.
Yeah, and then I think the world is recovering, or is only the U.S. is recovering? I can't keep track with the Omicron in various countries, but
well, I'm gonna reach under the table, touch some wood here, and hope that things keep on a positive track because that's just good for everybody.
Yeah. Well, sounds good. So we are going to come back here in a second and answer your questions. So send out the questions and. Send Brian a subscription. He loves those subscriptions.
I do love subscriptions. It's fun. We get little pings on our phone.
And we'll see you guys in a minute.
All right, gang. So we have some questions. Well, you have some questions, and we have some answers. So the first one we have here is from Pakala Prasad, and it's: I have a green card EAD. If I take a second job, do I need to inform employer for switching to green card EAD? Any restriction on what type of second job I can take up?
Okay, so it's good questions.
So
Do you need to inform of switching green card EAD? So I have a green card EAD, I take a job. Do I need to inform of switching? I don't know what switching means. What was the previous EAD? Maybe
Well, no,
H-1B?
yeah, that's what I'm thinking of. So I'm on H-1B status. I have this green card EAD, and effectively you abandon your H-1B status when you start using that green card EAD.
If you're using a different employment authorization document, you want to tell your employer.
Yeah, it's the right thing. They're eventually going to ask you anyway when they have to re-verify your I-9, for example, or if it comes time to file an H-1B petition, H-1B extension for you, and you'll have to tell them, "Oh, it's not necessary. I'm using this EAD right now."
Yes. Now, what kind of second job do you think he can take?
I don't think there's really any limitation on that, as long as ultimately your intent is on a full-time basis is to accept a job per your labor certification / I-140 or in a same or similar occupation full-time per supplement J.
So the answer I think is right on what you just answered. Yeah. As long as that doesn't take over in the future and becomes what you want to do after you get your green card.
Yeah, and in doing this job for a long time at this point, when something takes over is a classic issue. It's something gets out of hand, and you never really intended it to happen that way, and that's where people sometimes get in trouble. Yeah. Keep on going through these here from Sweet Seller. Hello, Sweet Seller, a frequent viewer. So. Visa Bulletin says corrective action in EB2 due to EB5. What is the corrective action? Is that retrogression? Does legislation allow corrective action on EB3 due to EB5?
I'm not sure they said corrective action. The visas can, in addition, under the relevant statute, any visas not required in the 5th employment-based preference category are made available in the 1st employment-based preference category, and visas not required in the 1st employment-based category are made available in the 2nd employment-based. So these visas cannot be made available. So I don't think they're saying corrective action unless, but it says Visa Bulletin Section D. So I'm reading the release here.
Yeah.
Man.
Well, Sam, I'll keep. If you want to take a read, I'll go on and hit up the next question.
Sure.
Or that one.
Yeah.
So there you go. For Pakala Prasad, for green card EAD renewal, can I file 180 days before expiry, and can I work 180 days after expiry? Am I correct in my understanding? Answer is a simple one, yes. So for anybody who's not aware, when you are renewing your green card C9 EAD category, a timely filed extension gets you an extension of the EAD for 180 days past its expiration point. And you can file 180 days before it expires. So you kind of have a fair amount of breathing room there in terms of how much of having a good chance of getting that EAD approved before you expire. So let's see what else we got on the list. And here we are, another question from Pakala Prasad. So if I try to move my category to EB2, will my daughter need to be reassessed for CSPA protection based upon how long it took the EB2 I-140 to approve, not the EB3 I-140 approval time? Yes, that's one of the concerns that we sort of expressed earlier during our presentation. Ultimately, they calculate CSPA time based upon how long it took your I-140 to be approved. And if you are transferring the underlying basis, you are transferring your I-140. And that merits a consideration of whether or not your children are still eligible under the CSPA. And obviously, the big challenge there still merits talking to somebody if you have a child that's anywhere close to the age of 21. However, if somebody is under 21, they don't really have a concern. Is the short answer of that?
Yeah, that's a good answer, Brian. Shall we go back to Sweet Seller's question?
Yes. Let me scroll back through the list here.
So this is an interesting question. Under the 5th preference category, there is the EB5 pilot program, which needs to be reauthorized by Congress, which has not been reauthorized by Congress. So what that did is that there is a freeze on all the EB5 applications right now.
Yes.
that are part of the pilot program, which basically that's the one that you buy into rather than opening your own business. You just put your money into like a big hotel or a big development. So these are not moving forward, and they have not been moving forward for a while because Congress has not acted on the appropriation bill. That has done is caused some of the unused EB-5 to go up to the first preference and then go down to the second preference because all the first preference is current. Yeah. And if that pilot program is reauthorized, it may have an impact on the EB-2 employment.
So it could jump up some.
And slow it down, yeah. And that could also explain the fast movement in the EB-2.
Get your green cards now. While they're still available. Yeah. So.
And that could mean when you say corrective action may be needed to be taken in the employment base, that does, in my reading, could be read as retrogression. Yes.
So here's a question from Centaur. These are the sort of questions that we were talking about before this. If there isn't enough interfiling into EB2, wouldn't USCIS at some point have to do vertical spillover from EB2 to EB3? Traditionally, that would be fiscal year Q4. Continued. I feel that they should look at EB2, EB3 as one single bucket and process by priority date to utilize all visas available. So
I think there is a fear of an EB2 retrogression because of the pilot program, and I think they're holding back, and they may feel that it's not going to make it to the EB3. You're right. Anything else you want to add, Brian? I mean, cut you off.
I mean, they are. In some ways, it seems like they are kind of treating them as a single bucket because, again, they're saying, hey, all you EB3 guys, don't wait over there in the EB3 category. Please come over to the EB2 category and get your visas here so we can use up these EB2 categories, EB2 visas. I guess, I mean, that says to me, we are trying to get these things in order. They're saying, we know you have EB2 approval, so just come back and get your EB2 green card.
I mean, obviously, they are not anticipating an EB3 movement.
Yeah.
And that is in the language in this report here. It says these visas, which is the ones available in the EB2, these visas cannot
be rolled.
Cannot.
Yeah.
That word here, I'd like to kind of understand why they say cannot be made available to applicants in the third employment preference category because there's a significant number of non-citizens awaiting visas in the second preference category. The visas are required by statute to be used for the second preference category. Really, really interesting. I need to dive into that a little bit and see if we can get an answer by next week because that came in too quick for us to kind of, but this is, yes, very peculiar language, I agree. And it still leaves.
It says those can never go to the EB3 category, which is weird.
I know there's a 10,000 limitation on the other workers EB3, which is people with less than a bachelor's degree. But under the Visa Bulletin, it says visas are 28.6% of the worldwide level plus any numbers not required by first and second preference, of which not more than 10,000 may be provided to other workers. So it seems to me that there is no problem with the downflow, but they do feel that there is a problem.
Well, again, if they slow down the Visa Bulletin EB2 and invite all the people who jumped into EB3 back to EB2, I mean, I guess that could be them saying we know we have the cases to utilize all these EB2 visas. And that could be why, because again,
so why are they inviting more people in the EB2?
I don't know, but if I...
So that's the question that we've asked each other before the presentation, and we all looked at each other, and nobody came out with a convincing answer. So yes, you raise a good question, and we don't have an answer, but maybe by next week we have time to kind of dig into it deeper.
Yeah. Here's one from Sarvan Kumar Banaparthi. Hello, and thank you for everything you do. We just have a little bit of fun once a week, I've downgraded to EB3 and got my EAD and AP, and I'm planning to travel to India this summer. Should I use AP or apply for a visa? My priority date is January 28th, 2014. So, simple answer, my take on this is get a visa if possible. That AP is a great backup if the visa's not going to work out.
Good answer.
Again, if you enter on the AP, you come back as a parolee, and you are not in H1 or L1 or H4 status, whatever your status was before when you enter on a visa. It's maybe possible to get back into a non-immigrant status through a USCIS filing once you return to the United States, but the big benefit of coming back on a non-immigrant visa is, if you have 2 layers of protection. If your non-immigrant status falls apart for whatever reason, you can have the adjustment back up. If your adjustment, heaven forbid, falls apart, you have your non-immigrant status back up.
Yep.
Here we are. And so Straven has a problem. Visa slots are not available for June and July. Please advise. Thank you. So that's the problem. If they're things have been a little bit better. I'm surprised you can't get anything that far out due to the Dropbox policy. People have been able to get visas while abroad. One of those things I can say, Straven, is that if you go back and check the scheduling portal, sometimes dates
Do open up.
They do open up, but
It's June, July, but that's going to change. I think by June and July you're going to see improvement. It's very simple. It's not complicated. It's a date. You either go with these dates that you want to travel. If you have maybe a wedding or something of important, you got to go on that date. You got to go on that date.
Yeah.
Now, is there an appointment? Keep checking. You cannot make an appointment. Come back on advance parole. You can make an appointment, go in, and smile and get your visa. If they're giving you a hard time, forget about them. Ask for your passport. Come back on advance parole.
It's
a no pressure situation, which is a wonderful situation to be in.
That's why it's great to have the advanced parole. Yeah. So here's a question from Sweet Seller, and it seems to be a kind of a slightly different subject, but that sounds okay to me. Asking for an elderly relative needing help. He got a non-expiring green card in 1979, predating all of us, predates me, on the basis of PhD, and he's lived in the United States since then, never applied for citizenship.
Continue.
Has the rules changed for any time which forces him to switch to an expiring green card?
So I am assuming that your relative is living in the U.S. And the answer is yes. The rule has changed, and that green card he has, if he's living in the United States, has expired a long time ago. But no big deal. Just file for a renewal. If he's living abroad for more than 1 year, that green card, obviously, he has to go back to the consulate for a reissuance of the green card on coming back on a visa, if they approve it. But if he's in the U.S. and he has a non-expiring green card and he's been living here forever, he needs to renew it, but it's not the end of the world.
Yeah, I think we talked about this maybe last week. Your green card is evidence of your permanent resident status, but your permanent residence doesn't expire just because your green card expires.
Yeah. I had a client about maybe 8-9 years ago. He was like 50, 60 years old.
I think I know who you're
and
talking
he
about.
handed me this green card, and I looked at it and I said, "What the heck?" He said, "Yes, my green card." I said, "This green card was issued like 40 years ago or 30 years ago." He said, "Yeah." I said, "You need a new one." He said, "I traveled back." He traveled in and out of the U.S. 10 times, 15 times, and every time he comes back, they say, "Just you need to get a new green card," and they let him in. So it's not a big deal.
Here we are, a question from Subha Mahadevi. Am I eligible for interfiling if I downgraded to EB3 in October 2020 and subsequently moved to another company using AC21 using a I-45J from a new employer? No new perm EB2 I-140 with new employer. So the answer, assuming I understand the facts, and I'm going to clarify them a bit, it's going to be a no. But Sam, what's your take on this one?
Yeah, because the other I-140 is with the other employer.
Yeah. So you can't, when you interfile to an I-140, you're saying, hey, I'm intending to take the job that's on this I-140. And if that I-140 is not with your current employer, if you're interfiling to that prior EB2 I-140, you darn well better be getting a supplement J from that employer, and basically knowing that you're accepting employment with that company again.
Can you please add that scenario to our chart, Brian?
After you've used AC21 portability and joined a new company, you can't.
You cannot interfile.
You cannot.
That's a huge one.
Well, unless you want to go back to your prior employer, and I had a consultation with somebody about this, sometime I think on Friday, and a lot of people when I say, well, if you go back to your old employer, they go, this person good. So happier where they were, obviously. There we are. Going to keep on going through the list here. From Ashok. So my priority date, April 2013. My old EB3 I-485 October 2020 application is at Texas Service Center, and new 485 EB2 December 2021 in MSC. Do you recommend me to interfile my old EB3 application to use EB2? Interesting scenario, Sam.
So prior to 2013.
I'm going to get out my Visa Bulletin for this one.
Yeah, my old EB3 485 2020.
EB3 I-45 filed in October 2020.
April 2013. Yeah, he's current. His current. Well, I mean, obviously he's current under
April 2013.
May 1st, 2013.
So he's not current in the EB3 category anymore, and that EB3 adjustment of status isn't doing anything for him right now.
Yeah.
And the I-485 it's capable of being approved at any time and getting him a green card. The question is, can they do it? And this is in this scenario, I
would probably say yes.
It's worth consideration. Yeah.
I would say you have a yes. Again, you need an attorney to kind of open up all the files and go through a complete vetting before say go ahead and do it. But I would feel that this merits potential interfiling.
Yeah, I mean, with that EB2 I-40 filed in December 2021, I'd still question whether or not they can get to your EB2 I-45 during this fiscal year before the visas are wasted.
But this is October 2020, which is a significant time.
Yeah, meaning that's a case where they probably have done everything they need to approve it. I mean,
but if it's not current.
Well, if it's not current, that's why you interfile it. Yeah, that's why you might consider interfiling.
Right, but if they so do they jump ahead of the line because it's an older adjustment?
Well,
who knows?
Exactly. This is I sometimes have to enforce to tell people USCIS is a bit of a black box, but they have processing times for cases, and that EB2 I-45 has been processing for 2 months, and the EB3 has been that's like 14 months now. It's been in process. Mm-hmm. That's right within their approval window.
Yep.
So
and remember, with that old case that you have allows you to transfer employment because it's beyond 180 days. The December 2021 one is not within 180 days. So if you're contemplating transferring employment, you interfile, that you won't be able to do it for another 6 months.
Yeah. Good question. Here's another one. So from Raghupati Subarasu, two-parter. My priority date, May 2013. I filed EB3 downgrade on October 2020. I-140 and I-45 pending. Okay. So biometric done from me and spouse, September 2021. Took them a while. Refiled EB2 I-45 on January 2022. Got receipts for I-45 and I-45J. And here comes the second part. Biometrics we used for me and my spouse, but 12-year-old son got a biometric appointment on March 1st, 2022, which didn't happen for EB3 application. Okay, is there a part 3? There we are. Third part. I believe my date will be current in April. Do you recommend to withdraw all EB3 related applications? No.
Why would you withdraw?
Yeah.
Withdrawing is a step backward.
Yeah.
Zero positive in withdrawing.
They don't care if you have adjustment of status in 2 categories pending. They will treat it like a race between them, and whichever one your priority date becomes current and they can approve first, they will approve that case. Yeah. From Raghu Raman, priority date September 2012. I have EP2 I-140 and EB3 I-140 approved from employer A, downgraded in October 2020. I'm moving to employer B based upon EAD in March. Can I tell employer A to interfile EB2 in April?
Well, employer A.
To interfile to EB2 in April. So basically,
well, there has to be an intent
to join
the company for them to interfile in April. And if you tell the employer, if the green card is approved, I will join you again. Please go ahead and interfile for me.
Yeah, that's something you can do.
And I can promise you that I can do that. So yeah, you can, but you have to understand the intent. And we had a prior discussion about your commitment to that employment because with supplement J,
you are saying you are swearing under penalty of perjury that you are intending to take the job set forth in that supplement J. So if in April you are no longer intending to work for employer A ever again, you can't interfile.
Yes. So you have to be careful. Again, that's one of the advantages of consulting with an attorney and lay it out for them and say, hey, listen, I need 20 minutes of your time, and I want you to look at this carefully for me so I can make a good decision because this is my green card.
Yeah.
Consult with an attorney with experience to guide you before you make those decisions. We answer those questions quickly here, but every case really deserves a lot more time than the minute that we get.
Anytime I talk with somebody about this, I say, wise to sit down and talk to somebody because, you've been waiting this for 10 years. You don't want to stumble at the finish line.
Yes.
So another one from Raghu, and that was the same question. So there you are. There we are. Question from Pakala Prasad. EB3 ROW unused quota will come to EB3 in fourth quarter. Then EB3 might move forward. That's not what they say in this thing. They say those visas aren't coming to the EB3 category. I personally have gotten out of the Visa Bulletin prediction game, though we did give a little bit of prediction earlier.
Only to the extent that we have any reason to.
Well, we know EB3 is most likely to move when in fiscal year in Q1 of fiscal year 2020 of the next fiscal year, because that's when the visas become available. That's when the fresh crop of visas come up.
Yeah.
There we are from Raju Khalidindi. Priority date December 2013. Downgraded from EB2 to EB3 in October 2020 by amending EB2.
Ouch.
Yeah. Preview of the answer you're going to get there, Raju. Does USCIS cancel EB2 in the case of amendment, or does FOI request will have the updated status for the EB2?
So to clarify, when you amended your EB2 to EB3, realistically speaking, EB2 is gone. You can reestablish it, and then you have an I-140 in the third preference category. You could reestablish the second preference category.
New I-140 filing. Yeah.
Now, filing a FOIA, does that clarify what they've done? They may or may not. You shouldn't be relying on FOIAs because it could be it's done in their database in the system in the background, not necessarily on paper.
I find, Freedom of Information Act requests are often incomplete, and that's not, when there's a FOIA request out there, it doesn't mean they're looking at your case and analyzing the issue. They're not going to fix something like that before they send out a FOIA response, but who might catch on to it is the officer who's finally reviewing your case in the end.
You have to assume that your EB2 is gone. Any other assumption is inviting disappointment for you in the future. So you need to go and just say to your employer, it's amended, it's gone, I need to file a new I-140 in EB2. And if you rely on, let's assume by mistake, that EB2 is not gone, USCIS has how many years, Brian, to reopen the case and take the green card?
I believe it's 5?
5 years.
Yeah.
So they can come back to you, and trust me, you do not want to receive that phone call. I have received phone calls for clients where USCIS more than once said, we have issued this green card in error. We must take the green card away. We're very sorry we did that. And in one incident, it was incredibly professional. It was done very nicely. In the other incident, it was completely botched up. They didn't
It's
care.
not just the fact that you lose having the green card. It's all the things you did and your reliance upon having a green card in your
You're
personal
right
life.
on. Yeah, maybe you bought a house because you got a green card. Maybe you invested, or maybe you took a job that requires a green card, and now there's no green card.
Yeah.
So yeah, don't do that. Just assume your EBT is gone. Accept that. Move forward.
Yeah. So here we are. Can I use EB3 AP to travel and EB3
Interfile
AP
to
travel
EB2.
and interfile to EB2 later? So is
Yes.
EAD AP tied to employment category?
Yes, because the EB3 AP, when you interfile, becomes an EB2 AP.
Yeah. It's not. There's no such thing as an EB3 or EB2 AP. It's attached to the adjustment of status case, which is attached to your I-140.
Whatever that adjustment status travels to happily, right?
Yeah.
Right. If you don't have a rejection of the adjustment status, the advanced parole
Survives. Yeah.
is in good shape.
Yeah. Here we are. So considering how EB2 movement's doing, what do you think about the priority date of April 2015?
Projection and the projection. Shall I bring my? Is this the time to bring the crystal ball, Brian? It's sitting over there. We will not bring it.
It's tough. I mean, let's think about where we are. All right. I mean, we're gonna give it a little bit of serious consideration for you. EB2 final action date is in May of 2013.
We're in 2013.
Yeah. I mean, it's not.
That's 2 years.
Yeah, I don't see that.
That's a long time.
I mean, they're moving good chunks on EB2, and they're moving. There's a good chance we can be in 20. So we go out and read other people's predictions as well, and some more in our notes here that some people are predicting we get into 2014, but 2015 is quite the stretch.
Yeah. Not yet.
Yeah.
Hang in there.
Yeah. So here we are. Have you seen recent approvals or overall processing time improvements from the Texas Service Center on cases filed in your office? Thanks for your input.
So we don't track them that way. I wish we track them that way in terms of improvement. We just handle them as they come.
Yeah, we try not to fret about, because ultimately nobody can control where their case is at. You file to the address that USCIS tells you to file at, and they route it to wherever they want. We did look at the data, maybe it was about a month ago at this point, where we did a presentation where we really dug into USCIS's case processing numbers, and Texas Service Center is doing faster, but they came into the adjustment of status deluge in October 2020, having more cases in their office already. That's why they feel slower. They had more of a backlog versus the other service centers. Yeah. So, I mean, and I think we saw they actually managed to eclipse Nebraska in terms of processing volume.
Yeah, in terms of rate of processing.
But ultimately, they have a bigger
cases
a bigger backlog to shovel through. They're in a bigger hole.
Yeah.
Yeah.
But we cannot answer that question right on point. Unfortunately, we don't track them that way.
So from Centaur, a frequent viewer, and that's always appreciated. Related to the EB5 spillover to EB2, does it even matter if EB2 doesn't have enough pending I-485s at this point?
So EB5 spills over to EB1, and EB1 spills over to EB2, and EB2 should spill over to EB3. So you're right, but the interfiling is kind of, they're speaking from both sides of their mouth. On one side, they're saying we strongly encourage because there's a very large number. And then on the other side, they say they're not going to go down to EB3 because there's a large number of EB2. To me, and the question is whether or not there has been a little bit of a change of interpretation in the way the Visa Bulletin is going to be handled. We don't know. We do not know.
Yeah, there's somebody new at the reins of it for sure.
Yes. So is it they're saying that there is a lot of cases hanging on the EB2 and we're processing as much as we can. We are not going to move them to EB3. We're going to use as much of them as possible into wastage. We're going to keep driving them into wastage because we really cannot move any from EB2 to EB3 because the fact that EB2 will continue to be we'll continue to have cases in our pipeline. And if that's the case, why are you encouraging people to move to EB2? except that they believe that if they don't get him now, if they drop him to EB3 in the fourth quarter, they're not going to have enough time before until the end of the fiscal year to process any EB3. So they can move him down, which is great, but and then waste is move them down, and 2 months later they're wasted because 2 months is not enough time to process EB3. So they want you to jump into EB2 now so they can move them faster. We're trying to interpret it, but it is inconsistent, at least from our standpoint. Where we're sitting here, we see inconsistency. But that's the only explanation I have, is that they want you now to process cases, not in the fourth quarter, so they hopefully can approve your case.
Yeah. So.
And we are at 7 o'clock, so we'll take one more.
Okay, but I think you're going to want to take one more after this one. It's not, so when will this be starting F4 interviews? So this is a non-employment question. This is a family fourth category.
That's a great question. When they're going to start? Fatima, Kareem, thank you for listening to us. And that's also in the prediction category.
So,
so
the consulates are operating.
So let's talk numbers.
Yeah.
Let's talk numbers. F4, there's 2 million cases backlogged. 2 million cases backlogged. Now, last time I remembered, there's 65,000 cases available.
For the record, this is the family-based fourth category, family-based immigration, brothers and sisters of adult U.S. citizens.
65,000?
Yes, Sam, you're right on. 65,000
available per year. Okay, there's 2 million cases backlogged.
Yeah.
Do the math.
Yeah, I mean,
divide 2 million by 65,000. You will know how many years behind they are, which is decades.
The other challenge is, the consulates have been shut down for a while. As I believe they're still trying to prioritize, immediate relatives and the higher categories.
Yeah. To the extent that your case is current, they should get on it as soon as possible.
But when is possible?
And that's the $50,000 question that we don't have an answer to.
Yeah. So let's spin the wheel and take one last question and see what we got. Well, let's take the last one we have.
A family case. We'd love to take family cases. Yeah. Why not?
So, can we process I-130 while I-824 is in process for spouse green card? Sure. Do you technically need to? No, presuming your spouse predated your issuance of your green card. But I-824 processing times are quite slow.
Yes.
Yes.
Absolutely.
Yeah.
With that, we end our presentation for the day. And if Abel is listening to us, I will be calling you to talk to you about your case. Have a great day, everybody.